Good evening, everyone. I think we're going to go ahead and get started. So great to see everyone here tonight. Thank you for being here. I'm Carrie Coogan, Deputy Director of the Kansas City Public Library. Want to welcome everyone who's here. Also want to welcome everyone from home or elsewhere. We're live streaming tonight at the library. You can check out all of our programming live streaming at kclibrary.org. You can miss all of the great programming that you couldn't be here for. So we hope you'll check that out. I also want to take a moment to thank our incredible co-sponsors in presenting this event, the American Association of University Women of Missouri and the Kansas City Human Rights Commission. Thank you both so much. We're grateful of your support for this event, but also for your longtime support of the library as well. So thank you very much. So we have an important topic tonight, and we're fortunate to have Alexandra Brodsky with us to discuss her new book, Sexual Justice, Supporting Victims, Ensuring Due Process, and Resisting the Conservative Backlash. The book examines ways to balance, the book examines many things, right? We're gonna get into some of that. But it examines at its base ways to balance the handling of allegations of sexual harm to be fair to both the accusers and to the accused, and we'll dive much deeper into other topics as well. Alexandra is a civil rights lawyer, author, and founder of Know Your Nine. That is a youth-led organization working to fight gender violence in schools. As an attorney, she advocates nationally for student survivors of sexual harassment, and her writing on the subject has been published in the New York Times, The Atlantic, The Washington Post, and The Nation. I'm also really pleased to introduce a new member to our staff, the library's Anne Kniggendorf. She joins us tonight in the conversation. Anne is a staff writer here and an editor at the library, but she's also a longtime Kansas City-based freelance writer. She is a graduate of St. John's College of Santa Fe and has a Master's of Fine Arts degree in creative writing from the University of Missouri, Kansas City, and she's also a veteran of the US Navy. So thank you, Anne, for doing this tonight. Again, thank you all for joining us, and I hope that you'll visit the tables of the many other partners we have with us tonight, both after the event, and we welcome you to take your time and have some great conversations. Please join me now in welcoming Anne Kniggendorf, and especially our special guest, Alexandra Brodsky.
Welcome.
Thank you. Thanks so much for having me.
You're welcome.
Neither of us will move
No,
for the
we
next
will not
hour.
move. We're going to be really, really still. Before we get started, I think I'd better mention to all of you here and all of you at home that some of what we're going to be talking about deals with sensitive subjects. You heard the title of the book. So we'll be talking about sexual harassment and sexual harm and some sexual abuse related topics, and so there won't be much in the way of specific stories about incidents, so we don't have to worry about that, but I just wanted to warn everybody and make sure that you're aware of the topic. So much of your book and your work depends on understanding what Title IX is. So will you please explain that before we get moving?
Sure. So Title IX is a federal civil rights law that's actually coming up on its 50th anniversary this June. And it very broadly says that no one should be discriminated on the basis of their sex in education. And it's really just this one sentence that's very broadly written that over the 5 decades since its passage, courts have interpreted to cover a whole range of forms of sex discrimination. So when I started in school, I thought that Title IX had something to do with women's soccer, and that was sort of right. You know, Title IX is perhaps most famously known for its incredible effectiveness in opening up athletic opportunities to women and girls in school. It also protects pregnant and parenting students who face discrimination. It protects protects LGBTQ students from discrimination, and it protects students from sexual harassment, which means that schools have to take steps to prevent sexual harassment from occurring, and if it does occur, they have to offer support to the survivor so that that person can continue to learn. And for me, the sort of big takeaway there is recognizing sexual harassment as a civil rights issue, right? It's recognizing the way that sexual harassment stops people from learning in the same way that it stops people from thriving in the workplace when they experience sexual harassment at work.
Yeah, that is on my list of things that I want to really get into because I found that really interesting. You founded the nonprofit Know Your Nine when you were 23. And it's what the name suggests, right? So it's helping students know their rights under Title IX, right? Sort of meant to be a guide, sort of?
Yeah, the impetus for starting Know Your Nine was really just that, I was in conversation with students at schools across the country, and all of us said, hey, it's great that there's this law. Too bad none of us knew anything about it when we needed it. And so we wanted to create these sort of accessible legal explainers about what the law is. And since then, Know Your Nine has grown to also do a bunch of policy advocacy and try to bring student voices to policymakers. But the heart of it is sort of what good is this law if people don't know how to use it?
Right. And I keep thinking every time I land on that, I think about how, when I was 23, I was not founding a nonprofit. That is not what I was doing. But before you did that, while you were still an undergraduate, you and some classmates filed a Title IX complaint against Yale with the Department of Education. So you already knew your nine then, in a way, right? And so I kept wondering, what was the complaint about exactly, and what did you hope to achieve by filing the complaint?
Sure. I should say that in many ways that was my education in Title IX, but I really had no idea what it could do until I was invited to be part of this process. So the complaint was basically asking the federal government to come in and investigate how Yale was responding both to private instances where someone who'd been assaulted would report, and also what I can really only describe as these annual mass incidents of sexual harassment.
Mass incidents?
I wish I had a better term for it, but
like hazing, or what are you talking about?
So a lot of it involved frats and male sports teams that would do things like march around the freshman dorms saying no means yes. One of the sports teams, they all sort of blend together, one of the men's sports teams stole a bunch of t-shirts that had been made as part of this project that some of you might have heard of called the Clothesline Project, where survivors will describe their experience and put it on a t-shirt to be displayed publicly, and the sports team basically stole those as a prank. And in these situations, the school, like it did when people came forward privately, just sort of said, that's too bad. I'm sure that we can all just agree not to do that again and move on. And that just wasn't respecting survivors' Title IX rights, and it wasn't making sure that they could stay in school. We heard stories about survivors who would transfer to different schools because they said, I just can't be here if I'm not getting the support that I need. And I guess one thing I should flag about the complaint is, so I know that there are probably some lawyers in the room. So Title IX is enforced in two different ways. People can file lawsuits in court, and they can also do what we did when I was in school, which is file complaints with the federal government. And the nice thing about that option is that lawsuits are really hard. You have to get a lawyer. Lawyers, are expensive. It can be really onerous and time intensive. And when you turn to the federal government, at least in theory, it's their job to do all that work.
Okay, lawsuits are hard. That's your takeaway tonight. That's my takeaway. Lawsuits are hard. Okay, so it was a lot of students. So it wasn't just you and a few friends.
No, I think it was 16 of us, of students and recent alumni, but really, speaking on behalf of a larger group, I would like to think.
Okay, so you filed the complaint, and then did you get the results you wanted, and what were the results?
Oh, that's a good question. Yes and no. So, okay, here's the positive part. The positive part is that the Department of Education announces they're going to investigate Yale. Conveniently, total coincidence, I'm sure, Yale decides the next month, we've just decided to overhaul our sexual harassment policies. We were meaning to get to that anyway. Here, we're doing it now. And I think Yale has genuinely improved the way that it handles these complaints. The thing that was frustrating about the investigation is that the Department of Education, at the end of it, came to us and said, we totally agree, school was violating the law 100%, but we're never going to say that publicly. What we're going to do is enter into this basically settlement agreement where the school agrees to do certain good things, and in response, we won't find them out of compliance with the law. And that was really the Department of Education's modus operandi at the time, and was frustrating for student activists because rather than being vindicated, the message that the public received was actually everything was fine all along.
Of course. And so you make some mention in the book of having had some incidents yourself of sexual harm or harassment. Are you willing to talk about any of those? And did they lead you toward this sort of advocacy and that initial desire to join the group that filed the complaint?
Yeah, I mean, I think that it is unfortunately true that
most of us do.
Yeah, I think a lot of people, I think particularly a lot of women, come to this work either because they have had an experience of violence or someone really close to them has. And I think that I sort of take it as a given when I'm in a room of advocates that most people probably are coming to this in some way, a personal way. And I will say the only thing that makes me hesitant to talk about that sometimes is that I think my experience, particularly as a young activist, was that policymakers or members of the media would look at someone who was speaking in part from a place of personal experience and say, well, you're just very emotional about this, so we have to turn to someone else to figure out what the policy solutions are. We have to talk to someone else as an expert, and not recognizing the truth that survivors are experts.
Yeah, for sure. And I said the words sexual harm just now, and so in the book you also talk about we need to understand what sexual harm is, and we're not from the same generation. I'll just say it, but I grew up with a different idea of what sexual harm is, and I imagine some people in here, I don't know how many generations are represented in this room, but we would all have a different idea of what's harmful sexually, and they're not. It's not like any one group is exactly wrong, but it's just that it evolves and the language we use also changes. Like I would never have used the words sexual harm until I finished reading the book, and now I'm going to all the time. But could you talk about what sexual harm is in the way that you're using it in the book?
Yeah, so it's funny that you point to those generational divides because I actually adopted the term sexual harm from my Gen Z clients who used it as a term that sounded a little less legalistic than sexual harassment, but was meant to be this expansive term to talk about unwanted sexual experiences. And to be clear, there are legal definitions of what sexual assault is, what sexual harassment is, and we can talk about those. But what I think my clients were trying to do and use this broader term was to say there's a lot of bad stuff that isn't illegal, right? And rather than getting mired in debates about, well, what kind of conduct could the police be called on to address, what kinds of conduct is likely to be prosecuted, to instead say, what are the sexual practices that we don't want happening in our community, and how do we build that world?
And then you've already mentioned that sexual discrimination, sexual harassment even, is a form of a civil rights violation, which I also never would have thought about at all. And so that was a really fascinating component of the book. And I see people nodding, so maybe other people have thought about that as well, with or without having read your book. But you say also that most people want to think of any sort of sexual violation as something that requires criminal law attention of some sort, right? And so could you kind of spell out what the difference is then between making it a civil rights thing versus a criminal thing?
Yeah, absolutely. I will say that there is a lot of conduct that is both a crime and what the kind of conduct that a civil rights lawsuit would be concerned with. So the sort of big Supreme Court case where the court recognized that employment discrimination laws prohibited sexual harassment was about a woman who worked at a bank and had been repeatedly raped by her supervisor. So that is obviously both a crime, but also a threat to her equality, right? Because she didn't feel safe coming into work. She started using all of her paid sick leave so that she didn't have to come in and see this guy. And then eventually she got fired because she had been using all of her sick leave. And you can imagine how harassment can then function to thwart that individual woman's progress. And then also, if we recognize who is sexually harassed, that's going to entrench systemic inequalities, right? If you imagine how many women there are who have this experience, how many queer people there are who have this experience. And so for me, thinking about sexual harms of many kinds as a civil rights issue is in part really about focusing on the remedies, because when we think about sexual harm as a crime, the obvious solution is, okay, call the cops. And there are survivors for whom that is meaningful. But there are also a lot of survivors, especially when we're talking about the context of schools and workplaces, where what they really want the most is just help continuing to do what they are there to do. They're looking for help staying in school. They're looking for help not needing to quit their job. And the police aren't going to be able to provide the remedies that they need. And so simply saying this is a job for the cops, all of the rest of us should get out of the business of addressing these harms is really going to leave survivors in the lurch.
Yeah, and I thought it was, in a way, easier to understand the difference between the two different ways to take action, you know, the civil versus criminal, when you think about kids on a college campus, that maybe somebody is just being harassed in a classroom by a teacher or something, and maybe nothing criminal has happened, like you said, but it turns into an impediment that's hurting the course of the person's life in some way, just like lack of a wheelchair ramp would, right?
Yeah, I think that's a great analogy, and yeah, that's a very good point that, you know, there's some conduct that is both a threat to civil rights and criminal, but there's a lot of harmful sexual practices that don't break any criminal law, especially in parts of the country that still have really outdated definitions of rape on the books, which is most of the country. And that, I think that's sometimes getting hung up on the sort of technicalities of what's a crime and what's not a crime, stops us from looking at a situation like you're describing and saying, this isn't okay, and we're in the position to help.
Yeah, and you mentioned Michelle Venson just a minute ago, the woman who was repeatedly raped by her employer at a bank, and that was in the 70s, I think. But I wondered if you would talk just a little bit more about that and then read a passage from that section.
Sure. Yeah, so this is actually a pretty fascinating moment in feminist history. So sexual harassment wasn't really a term that a lot of people were using until pretty recently. And then as feminist activists and feminist lawyers were trying to figure out how to use new civil rights laws to combat these problems, they came up with the theory, which I happen to think is right, that sexual harassment is a form of sex discrimination prohibited by any law that prohibits sex discrimination. So in the case of Vinson, Title VII, which is an employment discrimination law that, among other things, prohibits sex discrimination. And there was a lot of discussion within feminist circles of, it makes intuitive sense that sexual harassment is sex discrimination, but how are we gonna explain that to a court? You know, what is the precise theoretical argument about why this is so? And there was lots of debates among the courts, and then the Supreme Court, in this case brought by this woman who had worked at a bank, said, yes, it's sexual harassment, but we're not going to tell you why. They just accepted it without any kind of explanation, which in some ways is nice, because if, you know, I don't know that I would roll it back, because if they thought about it harder, they would have come out with a different result, and I wouldn't want to risk that. But it's actually led to some continuing confusion among the courts today.
But when this happened, wasn't that part, I don't know the words, but wasn't that clause or whatever it was only like 2 years old that had just the sexual harassment thing? Is that right? Was it 72 that?
So that's right. So the Civil Rights Act of 1964 included Title VII, which is the employment law. Okay, and then Title IX is 1972,
okay,
which
and then this was
sex discrimination.
74?
I think that this went up to the Supreme Court in the 80s, but as I said, lawsuits are hard, so it probably started a lot sooner than that.
Okay, sorry. Okay.
So it started 3 decades before. Okay, so here's the passage. Vinson's harassment kept her from being able to do her job. It threatened her and her economic livelihood. It deprived her of the opportunity to show up at work on the same footing as everyone else. In fighting back, she proved that sexual harassment is a civil rights issue, a profound injustice for individuals and for society. For me, learning to think about responses to sexual harms outside the criminal system isn't just about the mechanics of law. It's a philosophical shift. Earlier, I observed how rarely we hear about survivors' lives after harassment. Instead, we focus on the assailant and his punishment alone. We fail to center survivors in their own stories and the action of their own lives. As I see it, this is a criminal law mindset. The victim falls out of the picture, just like in a criminal prosecution. Thinking about sexual harassment as not just a crime, but also a civil rights issue expands our view. Social justice movements fought for civil rights legislation to root out inequality, both to help wronged individuals rebuild their lives and to end systemic injustice. So when we approach sexual harassment as a matter of civil rights, we see violence in its full context, the circumstances that give rise to it, the material impact it has on survivors, and the effects that ripple out afterward. We are guided not by the state's simplistic thirst for punishment, but by what victims need to ameliorate the harm and build a more just world. I think we should bring the civil rights lens to every question about harassment, whether it be how to design a smart policy or to how best to support a friend. As I see it, our community and institutions can choose to embrace the values that motivate civil rights legislation, or they can adopt criminal law's narrow, punitive approach.
Thank you. And I really like that, that your approach isn't just about women as accusers or victims. I am the mother of 2 young men, so we have all sorts of conversations in my house that, I different conversations from ones that I would have if I had daughters, I think. And so it's really, it feels good to see you extending fairness to men. But I did read that you have had some pushback from women for taking the stance that men need to be shown compassion too, which seems outrageous. But how is attention to the accused not inherently anti-victim?
Yeah, so that's a big question, and I should start off by saying that a lot of our discussion about this is inevitably gendered, both because most survivors are women and most people who commit sexual harms are men, but also because the politics of sexual harassment are really gendered, right? When we're generally concerned for the accused is concern for men. But the asterisk I always feel the need to put up front is that people of all genders hurt people of all genders, and men are more likely to be sexually assaulted themselves than to be falsely accused of sexual assault. So concern for men in the context of sexual harassment is first and foremost concern for them as survivors. But what really brought me to write this book is that I felt frustrated by the public conversation about sexual harassment that, particularly in the wake of Me Too, where it seemed like people felt like they needed to pick a side, right? Either they were on the side of survivors or they cared about fair investigations and people who'd been accused of sexual harassment getting to tell their side of the story. And I think that just isn't true as a matter of our values and also just as a practical matter. So as a matter of our values, I care about supporting survivors in school because I want them to have the chance to learn, right? I want them to have the chance to build the lives that they want. I care about survivors in work because I know how important economic security is for all people, especially women, and I want to see a public life that is representative of all people. And all of those things also mean that I don't want someone to be unjustly expelled from school. I don't want someone to lose their job for something that they didn't do. And so to me, the values feel really aligned. And also, just as a practical matter, if you listen to what survivors want and you listen to what people who have been accused of these harms want, so much of it is the same. They want the chance to tell their side of the story. They want the chance to be heard by people who they believe are unbiased, right? Who haven't, predetermined the outcome. And so a lot of the fixes that we can make to have schools and workplaces and other institutions investigate these harms really will benefit everyone.
Okay, and you write that you kind of blame media exposure, or I guess media, just stories in the media on giving people the false idea that they need to choose a side, because either people aren't talking about it in their own communities maybe, or people don't have direct experience with this themselves, so they find these sensational, sometimes, media stories, and then that's where that dichotomy seems to come in, right?
Yeah.
And so why is that so dangerous?
Oh, I mean, I think it makes the problem just seem so much harder than it actually is to solve. Because if I had to choose a side, if I felt like anything I did to help someone on one side of the equation was unjustly coming at the cost of the person on the other, I would feel really frozen. I would feel like, let's just throw up our hands and let someone figure out how to do this because it seems really hard. But when you realize that what we're trying to do is put together systems where everyone is treated like a human being, where everyone is heard, it all kind of comes down to minor policy disputes, not this big war of intractable conflict.
Okay, but even so, you write that you are worried about the himpathy thing, and you're wondering if you're coming down on the right side. So first, I wonder if you can tell us what himpathy is. It's hard to even say himpathy, but then also, are you really wondering if you're on the right side?
Yes,
Okay.
This was the hardest thing about writing the book. So I borrowed this term himpathy from this philosopher, Kate Mann, who has talked about the ways that for so many people, even those of us who identify as feminists, our first reaction when we hear a story of a man who has hurt a woman is to say, oh no, what about his future? Oh no, how hard this must have been on him. And the example that she uses in her book, which I think is just the perfect encapsulation of this, is Brock Turner's rape of Chanel Miller, which I'm sure that many of you are familiar with. This is the Stanford swimmer, where a jury convicted him, right? A jury decided that he sexually assaulted this woman outside behind a dumpster, and then the judge, in explaining his short sentence, said, he's just such a nice guy with such a future in front of him. This has already been so difficult, and it seemed as though any concern for Chanel really fell out of the picture. And so the whole time that I was writing this book, I was thinking, I really believe that these values, that we don't have to pick a side. I really believe that it is possible to be devoted to survivors and also thinking about what's fair to the accused. But what if this is what everyone who's engaged in empathy thinks, right? There probably aren't a lot of people who are engaged in empathy who think, I'm obviously a misogynist who, isn't concerned with rape victims. And it was really tough for me as I wrote, as I interviewed people who'd been accused of sexual harms, to stay on the right side of that line.
Yeah, and that guy got, 6 months instead of 6 years?
Yeah, it was.
So it was a really dramatic difference.
It was a very short sentence, as these things go. I will say that it was, I remember my primary reaction at the time being, I can't believe he was convicted, because convictions for sexual assault are so rare that. 2%,
did you say?
Yeah, it's really, really quite small. And that, so for me, that's always sort of the extra level of despair when talking about the Brock Turner case, that in some ways it is extraordinarily good result by the logic of the criminal justice system.
Good results, six months instead of 6 years. But we got him. So just a minute ago, you talked about how men are more likely to be victims of assault than they are to be falsely accused of a sex crime, which is so striking. You quote Tarana Burke, the founder of the Me Too movement, as saying, men's first role in this movement is as survivors, if that's the case. But it also seems like that idea about men is maybe a little bit of a hard sell to the general population. Is that right?
Yeah, I think that's right for a number of reasons. And I think that all of these end up hurting men most of all. So I think that a lot of people have trouble imagining men as survivors. Have stereotypes that it must be, well, men like any sex that they can get, so it must be that he enjoyed it. Or, well, if he was a real man, he would have fought back, and so this must mean he wanted it. And I will say this gets in the way of survivors accessing the care that they need. So I'll tell you 2 stories from my cases. I should give the disclaimer that I'm not representing my employer here today, but in my day job, I'm a lawyer. I represented a really young boy, elementary school, who had been repeatedly sexually assaulted by his classmates in the locker room. And when his family went to the school, what they told him was, well, if this was a girl, we would do something about it, but he's a boy, so this is horseplay. And then they said that again in a deposition. So they didn't, this wasn't a slip of the tongue. They really believed this. And that meant in a very concrete way, they were unable to see this boy as a victim. And I also represent over 100 men who were sexually abused by a single doctor at Ohio State a couple decades ago, Dr. Strauss. And so many of them literally were not able to recognize that what had happened to them was abuse. And part of that has to be that the visions of sexual violence that we see are always men hurting women.
Where is the Me Too movement now?
Oh, big question. In part, I feel like we won't know until the next wave. I feel like we tend to talk about movements as discrete chunks, when in truth, of course, it's a long civil rights
part
movement.
Of a continuum, yeah.
Work building on, the stage before. And so sometimes I hear people say, like, Me Too is over, but what is happening now post Me Too? And it strikes me that we are still riding that energy, and that will build to another crest at another point.
Okay. Well, let's go back to college campuses, because I think that seems to be your primary area of concern, at least just about the primary area of concern in the book. But is it possible to characterize the climate around sexual harm reporting on campuses nationwide? I went to high school and college in the 90s, so I assume it's a lot different now, and I'm about to have a college freshman. So, I really wonder, what is it like now?
I think it has changed so much in both good and bad ways. So I think that the unambiguously positive story compared to when we were in school is that students today know their rights in ways that we definitely did not. I remember in an op-ed once when I was in college, some friends and I used the term rape culture, and people just lost their minds. Like, what is this term? You're accusing everyone on campus of being a rapist. And now you talk to a 16-year-old and she's like, I learned this from Tumblr, when I was 12. And, students are coming into school already knowing about their rights, able to stand up for themselves. I think also just having a much richer understanding of what respectful sex looks like. I think there's been a lot of really great work disrupting sexual scripts where it's sort of expected that, at least in heterosexual sex, that a man will chase a woman until eventually she relents, which was very much the dominant narrative when I was in college, a decade ago. I think the bad news is that all of this cultural progress spurred a policy backlash. And so during the Trump administration, Betsy DeVos, the Secretary of Education, passed these new really bad regulations that essentially require schools to put on mini criminal trials on campus when they investigate sexual harms, and also reduced when schools have to address sexual harassment. So they only have to address the worst of the worst, generally only when it happens on campus. So I think it is more likely for a student to know that they can report, to know their rights when reporting, and I also think it is much harder to go through one of those procedures today.
Okay, so what should parents of girls and girls know versus parents of boys and boys? Like, what do you tell people who are just going to go into college? I mean, do they need to know certain things to protect themselves?
Yeah, I think that it is, I'm not a parent, but I will say that I think that students are always better off knowing their rights. And this isn't just a question of sexual violence, because, a daughter might be sort of intimidated out of taking advanced chemistry because the professor doesn't think that she's up for it. And so these problems arise in all sorts of contexts. But I have to think that, 99.9% of the work is ensuring that students never actually need to use those legal rights, right? That they they're part of a community that really is invested in, respect, in consent. And I don't know that that's maybe the sort of this is both optimistic and pessimistic. I don't think that that's an individual task. I think it is true that parents can have conversations with their kids, regardless of their gender, about what healthy sexual relationships look like, about making sure that they know that they can come to them if there's ever a problem. But I think that you kind of can't lean into having a respectful sexual community. That's collective work.
Good, I'm glad you said that. That's good. And then also that there's this balancing of fairness issue that you say is, this really ancient problem and isn't specific to sexual harm or any kind of sexual issues. But then you get into this thing called exceptionalism, which I just learned about from your book, thank you, versus preponderance. And I was glad to learn these words. So it's that these sexual allegations are handled in a different way from something like one student just hitting the other in the face. And can you talk about why it is that that's come to be, that we have exceptionalism in cases of sexual assault or any other sexual matters?
Sure. I think that it's, 97% sexism. So we have these really ancient beliefs that allegations of sexual harm are uniquely likely to be false because women are uniquely prone to lying. And we all know these stories because they are mad that the guy didn't call them back, because they got pregnant and needed to have someone to blame. And I want to be very clear, these are myths we have all heard, they're not true. In fact, all of the data suggests that sexual assault is no more likely to be falsely reported than other serious violent crimes like burglary. But there's not a movement of people really anxious about false allegations of burglary, right? There's not a movement of, the falsely accused burglars. And I think because it's, the narratives we have about false rape allegations tap into, I think, this particular anxiety of men imagining themselves for the first time being vulnerable to women. Right? There's this one context in which they imagine that women have power over them. Again, I think it's very clear from the way that these cases are publicly received that that is not true, that in fact the predominant response is sympathy. But it makes some people really nervous, and what that results in is unique skepticism when survivors come forward, procedures in and out of the court that make it much harder to prove an allegation of sexual assault than anything else. And I think also just this instinct that these allegations are too hard to figure out, that they're kind of unknowable, where anyone who's worked in a job knows that sometimes HR investigates things that might have happened in the office, right? There's a question, maybe someone embezzled something, or maybe someone was bullying a coworker, and everyone's like, sure, that's an appropriate thing for a boss to investigate. But the minute it's sexual harassment, there's this sense of, how can we ever possibly know without a federal judge donning robes?
Well, part of the origin is back in the 1600s. Can you take us back to the 1600s
Sure.
and talk about Sir Matthew Hale, who I had not heard of?
So, the context of this is I talk about how, these sexist myths are not just shaping our policy today, but have really shaped particularly criminal law from the start of the United States. And I talk about a British legal theorist. So, scrape the surface of exceptionalism and you'll usually find misogyny beneath. Our collective fear of scorned, lying, irrational women who falsely cry rape has been ingrained in our culture and law for centuries, no matter the baselessness of the archetype. It serves as a unified, animating force behind the casual rape apologias, explicit doubts, and flawed policies that stand in the way of justice for survivors and an end to the violence. If we look at how rape victims have been treated historically, especially in criminal law, we can recognize contemporary exceptionalism as just the latest iteration of a long, terrible tradition. We believe we need special protections from sexual harassment allegations because we think that these accusations are particularly likely to be untrue. The 17th century English jurist, Sir Matthew Hale, did not invent this exceptionalism, but through his influential writings, he gave it form and force that shaped centuries of Anglo-American law for the worse. Rape, he said, quote, is an accusation easily to be made and hard to be proved and harder to be defended by the party accused, though never so innocent. For this reason, Hale insisted, we may be the more cautious upon trials of offenses of this nature, wherein the court and the jury may with so much ease be imposed upon without great care and vigilance. As anthropologist Peggy Reeves Sanday has written, Hale's views were animated by the idea that many women accused men of rape in order to extort blackmail. That fear of women as manipulative liars was a common one during Hale's times and shaped rape law from the ground up. Women victims, for example, were expected to defer to the judgment of their husband or father as to whether to levy charges. A woman who instead came forward on her own behalf, quote, conjured the image of the aggressive Eve, whose complicity with the serpent made all mortal women susceptible to the wiles of the devil. They were prone to be sexually voracious and enticing, spiritually weaker and less rational, writes Sanday of the 17th century British attitudes. More likely than not, a woman bringing rape charges on her own behalf was either a scorned woman or one out to blackmail the man who seduced her. Hale's biases were not limited to theories about lying accusers. He did not believe a woman had the right to deny her husband sex and thought men should lock up wives who spent too much money. Presiding over a 1662 witchcraft trial, Hale dismissed evidence that proved the innocence of the two accused women and then sentenced them to death. Contrary to Hale's well-known concern to give rape defendants the benefit of the doubt, Sanday notes, he showed no evidence of giving defendants in witchcraft trials the same benefit. Hale's warning about rape accusations was also empirically incorrect. Rape is not and never has been an easy charge to make and a difficult one to rebut, writes criminologist Gilbert Geis. It certainly was not so before or in Hale's time.
So is it right you're better off being a witch than a rape victim? Is that right?
I think you're better off being a man than a woman in 1662.
Okay, just wanted to try to straighten that out. Okay, well, we'll stop and take questions in just a minute, but first I wondered, you do make references to, you give years every now and then of a particular change that took place, and most of them are shockingly recent. So I wondered if you could surprise and delight us with some antiquated rules that are still on the books, or any kind of law that we'd be really surprised to know about.
Yeah, so I talk in the chapter that I was just reading from about a couple of these really old rules, particularly around rape prosecutions. And one was that courts were supposed to give specific instructions to juries that they should be uniquely skeptical of rape allegations when the jury was sitting in a rape case. There were also rules that rape victims had to report much faster than anyone reporting any other kind of crime.
3 months statute of limitations.
Really short, and also that they needed to have witnesses. And for other crimes, your word is evidence, right? Maybe it will convince a jury, maybe not, but for rape cases, you specifically had to have witnesses, and that was the position of the model penal code until last year, I think it was. Maybe it was this year that the resolutions finally passed, but this is the fancy lawyers get together and tell the country what criminal law should look like. And that's what they were saying until literally just last year.
Wow. Okay, well, we would like to take questions from our home audience on YouTube. So if you want to...
Quick notice, if you have questions, please use the microphone so that the people watching at home can hear the question as well as the answer. And I'm going to start with this. Somebody watching online wants to know, if you could offer one piece of advice to young women today, what would it be? And I would add to that, what would it be for young men? And maybe it's the same advice.
Yeah. Whoa, that's a big question. I mean, part of me wants to say it probably has nothing to do with sexual violence. It's probably like call your mom, something like that. But make some nice friends. I think when it comes to sexual violence, and I think that this goes for people of all genders, I think having a really clear vision of how you want to be treated and understanding that you deserve to be treated with respect, that you deserve to be treated as a person who gets to make decisions about their body, might seem simple, but can be such a North Star. And it's not gonna, I wanna be clear, that doesn't protect someone from sexual violence, right? It's not like rapists go around and think, that person doesn't have a developed sense of sexual ethics, so I'm gonna go after them. But I think it does make it much easier for people to recognize when something bad has happened to them, and sometimes recognize that a partner isn't treating them right before it escalates. I think that takes help from parents and from other trusted adults, and also, the internet can help out with that. So I feel actually optimistic that young people are developing that today.
Could you elaborate on your section on why some people don't report?
Yeah, absolutely. So I talk in the book about how I really had this sense well through college that obviously everyone who's been sexually assaulted or abused should go to the cops. And I thought this even though I had not gone to the cops and had not even thought about going to the cops, but it just, I assumed that that's what everyone should do, because that's the narrative that I had seen on TV and in books and all of that. But I think, the truth is that survivors want a lot of different things. And sometimes the criminal legal system is set up to provide those. Often it's not. Sometimes a school is, a workplace is, whatever the other institution this happens within. Sometimes that institution can offer something different that a survivor might be more interested in. And then when thinking what these different institutions and systems can provide them, survivors are weighing that against the real harms that can come through reporting. So I think we see this particularly in the criminal legal system, where so many survivors end up prosecuted themselves. So many survivors face harassment and skepticism from cops. And so many survivors actually don't want to see the person who hurt them in prison, which I think is really hard to understand from the outside, but just is true. And I think that what that means is that our work as advocates is to expand options and help people make informed decisions about what is going to work best for them, rather than imagining that there's one obvious choice and that anyone who doesn't opt into that choice, therefore, isn't a credible victim, isn't deserving of our care.
Well, I have this huge problem with Title IX. As a former athlete who had no athletic opportunities after about the 7th grade, I was thrilled when I read about the focus on athletics, but now that does seem to be the only thing the general public knows about Title IX. And you mentioned Title IX, and the first thing you hear from really well-meaning, well-educated people is, isn't it wonderful now that the girls can play? But it's almost as if that was a conscious burial of the real powerful impact of the sexual assault opportunities to report under Title IX.
Yeah, that's really interesting. I think that it is certainly true that it is a lot more comfortable for a lot of people to talk about adding a crew team for the girls than it is to talk about supporting survivors, than it is to talk about access for trans students, than it is to talk about, keeping pregnant high schoolers in school. And so I think it makes sense that in some ways focusing on athletics is a sanitized version of the law. I also think that in some ways that public understanding in some ways is lagging because Title IX has evolved over the years. That I think it was really obvious when as soon as this law was on the books that, okay, this was gonna mean that schools were gonna have to add more athletic opportunities for girls. And it took the courts some time to recognize that this meant that schools had to address sexual harassment. It took some time for the courts to recognize that it protected pregnant students. I think it's really only in the last couple of years that Title IX has become an effective tool for queer and trans students. And that in some ways is frustrating because it means that this really rich, is just, is sort of seen in a flattened way, but I think is also a tool of progress that I hope that, 30 years from now, students know, about the next frontier of Title IX that we can't even imagine yet.
Hi, I also have a couple questions about Title IX. First off, the changes that Betsy DeVos made, have they been repealed under the Biden administration? And then my second question is, right now the Kansas legislature has a bill to ban trans girls from playing sports from kindergarten on up or something like that. I don't remember the details exactly. Would that be a violation of Title IX?
Yeah, both of those are good questions. So the Trump-era Title IX regs are still on the books, and that is because the regulatory process that Betsy DeVos went through to create these Title IX rules basically requires the Biden administration to go through the same regulatory process to get rid of them. So we have been told that we're supposed to get their new proposed regulations this month. There will be an opportunity for public comment, and then they'll become final. I'll believe it when I see it. I'm looking forward to it. In terms of the second question about Title IX protections for trans students in athletics. So I don't think that this is a place where the courts have yet spoken clearly and unanimously. As I see it, a law that categorically excludes trans kids or trans girls specifically from sports is sex discrimination, period, right? It's saying if you're cis, you can participate in sports. If you're trans, you can't. That strikes me as straightforward discrimination. And I would not, I don't have a crystal ball. I would not expect those kind of laws to necessarily last. I think that the harder cases under the law, I don't mean ethically, but under the law, will be cases where states create kind of a bunch of hoops that trans students have to go through to, let's say, prove that they've, transitioned enough in order to participate, where it is theoretically possible for trans students to participate. It's just not realistically possible. And I hope that Title IX is up for the challenge, but I'm not sure.
I was wondering if you could share more about what the civil process might offer survivors versus the criminal justice process, particularly class actions, like what you talked about.
Yeah, absolutely. So many things that the law can do for survivors. Okay, so a lot of you already know this already, but to sort of get us all on the same page. So let's say that someone's sexually assaulted. They can go to the cops, and perhaps what happened to them will fit into their state's definition of sexual assault, maybe not. If that's happened in the context of a school, a workplace, a medical facility, there will likely be some kind of civil rights law that requires the institution to respond in some way. Different laws for different contexts, but generally what that means is that a person can go to the institution and say, I need you to help me stay in school, stay on the job without having to deal with my harasser. If it happened in a medical context, like get me a different doctor because my doctor keeps harassing me. And the institution then has a legal responsibility to support them through that. Let's say that the institution doesn't do a good job. The survivor might then sue the institution for failing to follow civil rights law. They also might consider filing a civil suit directly against the person who hurt them, against their assailant. The truth is that people often sue the institution both because they see a path toward creating policy change that way, for pushing, let's say, their employer to adopt new practices to support survivors going forward, and also because the institution has more money. And I think the truth is just, if a 17-year-old is assaulted by another 17-year-old, they can win a civil suit, and they will get all $15 that person has in their bank account, which is probably not going to, pay their attorney's fees. A sort of key thing to understand about these different decisions is that, and the book talks about this at some length, if a survivor wants to take the criminal route, they actually don't get to make the decision about whether that happens. They can make the decision about whether to report to the police, but the police then decide whether to pursue an investigation or not. Prosecutors decide whether or not to bring charges. And so there are situations where a survivor really wants to see their rapist prosecuted, and the prosecutor says, I don't think I can get a win here. You know, I know attitudes in this community, they're not gonna believe you, so I'm not gonna bring this case. What's nice about reporting to an institution or bringing a civil lawsuit is that the survivor gets to make that decision. They get to say, I'm going to my school has to do something. They get to say, I'm finding a civil rights lawyer, I'm gonna file this workplace discrimination suit in federal court. I get to decide that this goes forward. And then the remedies are also different, where the criminal system, when it works, leads to someone being in prison, where institutions can provide support like workplace accommodations, like mental health care, and at the end of a civil lawsuit, often the result is a check, which can be really transformative to a survivor's life. That can mean that they have the ability to get the medical care that they need. They can move so that they live further away from the person who hurt them. They can take time off to heal, and all of that can be really powerful.
And I think we have time for one more question. Steve, do you have one from?
I do. We have somebody online wants to know, do you have any action items for people in Missouri or Kansas to support survivors and create change? And then they add, thank you for honoring Daisy Coleman and covering the justice system in Maryville in your book.
Oh, yeah. I hope this won't be a frustratingly vague answer, but to my view, the most important, I'm gonna say two separate things. I have two levels of response here. On a policy level, I think their most important job is expanding options for survivors and helping them understand what those options are. And so I think that can mean creating more civil causes of action for survivors to be able to pursue legal remedies outside the criminal legal system. It can be, if it turns out that you feel like your schools or workplaces are doing a bad job, it can mean creating better state laws that have better standards than federal law. So basically demand more of schools and workplaces than federal law does. And that's, to me, that's sort of the ultimate goal. What I will also say, though, is that for most of us, our primary relationship to supporting survivors is going to be as people, not as policymakers. It's going to be supporting a friend, supporting a family member. And I think it's really important to be able to distinguish those, because it is not our job to adjudicate an allegation when it comes to us from a friend, right? I've been talking about process, I've been talking about fairness. That does not apply when your cousin comes to you and says that he's been sexually assaulted. Your job there is to say, I'm so sorry, I believe you, what can I do to support you? Your job there is maybe to do some research about free therapy in the area if he feels too overwhelmed to do that right now, and sort of meeting that need in that particular role.
Thank you, Alexandra.
Thanks so much for having me.